Welcome. G'day. How are you, Nina?
Good, thanks,
You
Andrew. How are
completely
you?
recovered.
No, I feel like everyone is sick and it keeps
Can I,
coming
can I
back.
just say to you, everybody is sick. Everybody I talk to is sick.
I feel
But
like more regularly than previous years.
yeah, even my dog, when I went for a walk this morning, sneezed. So I'm just saying it's out there. Look, today's really much more about safety and the structure that sits behind safe work. And we've sort of put it that way for a couple of reasons. One, we're building up to our rights of entry. So we're going to talk at the end. We've got a case that looks at right of entry, and we've got our training coming up on right of entry, which will remind you how to get to. Can I just say this is sort of a unique opportunity? We don't often get someone like John to come along, who's from the old industrial school of how to actually use the strategy around right of entry. So we're going to do that a bit. But today I'm much more focused on there are quite significant changes happening throughout Australia at the moment in safety. There is also this emergent use of safety by unions to gain access to
Yeah,
sites
as an excuse.
as a method of actually trying to collect membership and grow membership base. So I think it's probably time we actually drill down a little bit on some of those issues. And of course, I want to also deal around inherent requirements because I think people have lost an understanding of actually what are the rules around inherent requirements, what you can do, what you can't do.
Yeah.
So when we talked about Little's case a couple of weeks ago, we got a really strong feedback around how an exciting case it was to use safety for pre-employment determinations of inherent requirements. But there's a lot more that sits behind it. So I know we've taken a bit of time having a bit of a rant at the start, but I thought that might be helpful. But why don't we just look at what's actually is going on around Australia at the moment in safety?
Yeah, but I think before we go on to safety, just a reminder that the annual wage decision comes out next Monday.
True. I'm saying 3.8, by the way.
You reckon 3.8?
Yeah, I reckon I'll go 3.8.
The union's asking for 9% ACTU for female-dominated ones, or just 5%. But I don't think it's going to. I reckon it's going to be 4.
You reckon 4? Because the government's 3.5, aren't they? And of course, the Australian industry groups are all going at 2%, which of course is an incredibly sensible thing to do, isn't it?
Yeah, but I think people are quite impacted at the moment. I don't know. We'll see. And
look, they are. If you have a look at restaurant closures, something that affects you and I intimately.
yeah, there's quite a lot of those. But also, the Fair Work Commission at the moment is pretty Labor-leaning as well.
Particularly that bench.
Yeah.
So, Tasmania and industrial manslaughter?
Oh, yeah. So this kind of came out of nowhere.
Can I just say, New South Wales, you're the only one left.
Well, they've actually started planning for
They
one.
have started planning.
But yeah, this one's not introduced by their government. This is by the opposition.
Yeah.
And I think it's really interesting because it has the normal things about how it defines industrial manslaughter. I think it's 18 million penalty, 21 years imprisonment.
Yep.
But it's not going to apply to any non-workers. So I feel like with the other jurisdictions, if you've been negligent and someone dies as a result of that work, that would be captured, wouldn't it?
Yeah, yeah.
But this one has been very explicit. It will not cover those situations.
Okay, well, that's good. Okay, and then we go to South Australia, which is actually playing a bit of catch-up, to be honest, with their...
Isn't it always?
I've just come back. So I think in South Australia, one of the things we're seeing is that authorised representatives or union members, when they come in exercising rights of entry, are allowed to video, they're allowed to take photographs, they're allowed to take measurements. That's been in Victoria since 2021. That doesn't mean they're allowed to live stream, okay? And then no one's allowed to live stream on entry anything in any state or territory. But what this does mean is in most states and territories around Australia, when a union organiser comes on with an entry permit, exercising a right, if it was in Victoria under Section 86, they are allowed to use their mobile phone.
Mm-hmm.
They can take photographs, they can take videos of what are happening, and they can record people and what they're doing so long as it relates to the specific event that they're inspecting.
Mm-hmm.
They're also sort of, I think, deepened the dispute process that sits under the safety legislation there.
Yeah, they're creating a new tribunal to deal specifically with WHS disputes.
Yeah. Funny thing, because throughout Australia there is dispute provisions and they're almost never used. And can I just say that's a dumb thing to do? Because if you have nothing to hide, you should be using WorkSafe. Okay, they may not come out in Victoria. You can ask as much as you like, but they probably won't come out. But nonetheless, it is a great mechanism of saying to a union, look, I'm placing this in dispute, let's get WorkSafe. So not a bad thing to do. Anyway, look, we won't go into detail about South Australia, just that the changes are starting to bring it up to speed in Victoria. Orders that come out of that tribunal have higher offence ratings.
Mm-hmm.
It's exciting and interesting, and it's starting to show that throughout Australia, safety is starting to grow in importance, and I think that's a really big issue that's come out of it.
And I think it's interesting that most of the changes are to do with the union as well. So there's a real drive by governments to increase their power, which is what a lot of the changes in this one tried to do.
They are. Why don't we go on to the next case, which is Mervyn. So Mervyn and Yamcoal is another workers' comp case. Now, over the last 5 weeks, we've deliberately showed you circumstances where an injury arises outside of a designated workplace, and yet it is still compensable. This was a woman who had a car park in the same building.
Yeah, and it was leased by the company.
Yep.
Yeah.
Parked a car there, and as she was getting out of the car and trying to get a laptop up, she slammed the door on her finger and
it had to be amputated.
Had to be amputated.
I freaked out when I read that. I was like, oh.
Yeah, I started putting on white cotton gloves when I was shutting the door too. But the funny part is such a dumb argument to say it's not a part of the workplace. It's accepted that she has to go to and from to get a workplace, and she goes to and from home.
Yeah.
And the tribunal held, no, look, it is part of the workplace. Laptop's part, being there and travelling because of and I guess this is the really big part of this case. Maybe a few years ago where you only worked 3 fixed days, or you worked 5 days and you used it, maybe it wasn't part of a workplace. But now with flexibility of work and people coming and going, then it does cause it, because she does have to go and get in a car to go, and next workplace is home. So interesting case, and again, something just to consider as Nina and I will rant on again about flexible work and actually how you have to put up barriers around what is and what is not flexible work, or these cases will continue to come and bite you in the leg.
It's such a weird case for him to run, though.
It was a weird case to run. Gomez and the mango.
Yeah.
Can I just say why I chose this case before we talk about it?
It was funny.
Yeah, I did. But no, I chose this case because this is about a woman who is not an employee slipping over in a supermarket on a mango.
Yeah.
That's the case.
That had been sitting there for 9 minutes.
For 9 minutes. But I guess the reason I put this in is we forget that in the day-to-day operation of our businesses, that there are very simple safety issues that are alive that create risk to us. And they don't just create risk to our employees, they can create risk to people who are entering our workplace. So this is a dumb case. It's a supermarket. They've got policies around cleaning up. It's inevitable that fruit will be dropped in a supermarket. It's inevitable it will be slippery. Mango is probably one of the most slippery of all. Just thought I'd put that in there. Unless you eat green mango with chili, that's quite different.
That's true.
But what happened is Woolworths, when they were arguing, said, look, we might have breached our duty, but it was only there for 9 minutes and it wouldn't have been detected between the last time of cleaning, and that was a reasonable process that was in place.
I think so. Her expert evidence found that their systems were more than adequate, but they weren't complying with it because they weren't doing it once every hour.
Yep.
But I don't know how they figured out the mango was there for 9 minutes.
It was on CCTV. The mango, you can see the mango, the eyes coming, it jumps out of the bag, lies on the floor. Then keeps looking at its watch going, 8 minutes.
But the key thing is, irrespective if they had complied with their policies, it wouldn't have changed it.
No.
She still would have slipped.
Yeah, so look, again, sort of funny case, part of the reason it went in. But the other one is, as I walk through our workplace, there would be once a week where I walk through and see a cable lying somewhere and move it. That's true.
As long as there's no mangoes on the floor.
Yeah, no mangoes. Not yet. But I suspect that mangoes are intrusive souls. They'll eventually attack us here. But a good case to have a bit of a chat. Let's move on to our next case anyway. All right, the Emu Run Tours. This is a case of a 6-wheel bus that was transferred to a 4-wheel bus.
Yeah, they modified it to.
And then there was a tyre that blew and it killed somebody, injured 20.
It overturned.
But the reason I put this case in is this is another case where individuals have been charged and successfully prosecuted. Okay.
And for doing stuff that goes against what the manufacturer says. So like the easiest way to get prosecuted.
But isn't it so often the case? You have a business that wants to get something done. It goes to somebody who's their expert or their tradesperson. They say, let's get this done. tradesperson does it, but doesn't reflect on the body of evidence around that they have control of, which is, if I want to do something to a vehicle, I've got to go to the manufacturer's specifications. And if I do that and it's contrary to that, I'm going to be personally liable.
Yeah.
So again, as we see over the last 7 to 8 weeks, we've seen an increasing number of individuals charged.
Yep.
In this case,
it was the director.
Yeah, director, who did the work. So let's move on to something that's much more exciting.
Exciting.
Linda Kelso. Okay.
This was sad, I think.
This is sad, and it's also in a New South Wales jurisdiction. You talk about the facts, but I'll talk about what can happen afterwards as well, because it is New South Wales.
Well, it was a medical practitioner who got into a car accident with another patient of the centre, and basically she developed adjustment disorder and anxiety, and although she tried on multiple occasions to be able to return back to work, she just couldn't. I think it was over a year that she couldn't return to work before they decided to terminate her.
Yeah, because
on the
inherent requirements. We'll talk a little bit about the cases around that afterwards. But in New South Wales, of course, there is the 2-year limit. So you have, after 6 months obligation period under workers' compensation, you can terminate. But within 2 years of the injury, you are able to seek reinstatement if there is sufficient work. It doesn't have to be the same job, but there's sufficient work within your skills and experience. So she could apply for a lesser job. It's unlikely given the fact that she's a medical practitioner, but she could subsequently seek reinstatement for a lesser role. So New South Wales is a complex jurisdiction. I want you to be aware of that. It is a complex jurisdiction with that reinstatement right. It is the only jurisdiction that has it. Why don't we go on to the big stuff?
The big stuff.
All right.
The main topic.
I want to talk a little bit about inherent requirements, and there's a reason I want to talk about it, because I just wanted to go through some basic principles. Okay. So first of all, what are the inherent requirements of the job? Bogues and Button was a case, I think, around about 12 or 14 years ago now, where a supervisor worked at the Bogues Brewery. Occasionally, he had to move barrels of beer, which were 25 kilograms, and as a result of a long-term injury, he was unable to do it. But the business managed without any loss of productivity. When Bogues was taken over, they looked at their workers' comp list and they said, let's terminate this guy. And what the court said is, actually, his job as a supervisor. That was the substantive part of his role, and the fact that he did these ancillary tasks from time to time, and there is no loss of productivity or profitability as a result of it, it doesn't fall within the inherent requirements. So the inherent requirements is the substantive part of the role the person is employed to do. So it might be that Nina and I, at different times, will go out and get coffee, or Nina will photocopy something that I need. If Nina breaks her arm and can't do the photocopying, or can't get the coffee because she's got a sore knee, that doesn't mean she's not fit for the inherent requirements, because she's employed as a senior associate who's a lawyer. So be very careful about being too brittle around what is it. But the next question then comes into saying, well, what happens if I don't have my job descriptions right? What if I'm wrong about that?
So common.
Yeah, and it is too common. Zeribus and Mondelez is an old discrimination case, and I use it because it's my favourite example of how bad you can be with job descriptions. But in that case, he was an elderly man. He was about 63. He was a confectioner by trade. Nobody believed he was fit for the inherent requirements of the role. Again, Mondelez took over the operation of this business. They subjected him to assessment. The assessment said he wasn't fit for the inherent requirements. He brought a discrimination claim. And the judge who was listening to it said, well, the difficulty I have is he's told me what the job is. The operations manager's told me the job, it's different. The HR manager's told me the job. So how can I be satisfied there aren't reasonable adjustments when I actually don't know what are the inherent requirements of the job? So he won only a small amount of money, but the case was probably cost about $500,000 in legal fees. My point about it is, if we're going to talk about the inherent requirements, the most important thing is to line up our job descriptions and task analysis. And anyone who says to you, I'm just too busy to update them, it's nonsense. You can't do a restructure and not focus on what is the capability statement of the person who's doing it. It is the core.
And it leaves you exposed, I think. The amount of times we see people and they're like, oh, you can't do it. It's like, but this is my position description. Where does it say that I have to do
I know.
that?
And look, the Belso case we just gave you sits on the back of the old High Court case in Cosma and Qantas, where there was a baggage handler had a knee issue. was sent away to do, data input and a whole lot of stuff. But the most important part of COSMA, which is for you as employers, the most important thing to remember is during that rehabilitation process, they made documentation which was constantly saying, these are not the inherent requirements of the job. These are either a get better plan or a return to work plan towards returning to the inherent requirements, but these are not the inherent requirements of the job. And after that period of time, a person can't do the inherent requirements. You've got a documented history that demonstrates the person's not fit for them. But if you don't have that documentary process, what you're left with is an argument around waiver or condonation saying, no, you've accepted there is a new role.
Yeah.
Okay, so you've got to be very clear to say when you're rehabilitating someone, whether it's workers' comp or not, that the roles that they have to do to be fit for the inherent requirements is the inherent requirements of the job, and not condone or just let things slide, because after a period of time, and what became clear after a year of doing another job without any of that structure around it, you've implicitly agreed to a new job for the person. Okay, so it's a really big issue. Okay, we're there. We've got to the inherent requirements. What have I got to do? What's the test when I say, is someone not fit for it after a significant period of not being able to? Cases Sturgiotto and Toyota, which says you've got to be satisfied the person is not fit for the inherent requirements of the job now or in the foreseeable future, and will not be fit now or in the foreseeable future with the reasonable adjustments that can be made to the inherent requirements. If you're satisfied of that, then you're able to terminate. Okay, so they're the tests.
But you need evidence, not just your own assessment.
Yeah, and there's more recent cases which say you must rely on your own independent medical evidence to be satisfied of that. You can't just rely on generalised medical evidence provided by them. There's been a few cases that have snuck through where there's some poor decision making, but the good law is that you do it yourself, and you cannot rely on medical information from workers' compensation. Okay, now let's go to the other part. I want to employ someone, but I don't know if they're fit for the job. So there's a case called Duncan and Kembler, which is a great case where Nina signed a contract and they said, you've got to do a pre-medical. They did the pre-medical after she signed the contract. There was nothing in the contract that said you had to be fit for the inherent requirements. But when the pre-medical came through, it was clear that this person was not fit for the inherent requirements. And Kembler Washtec was the name of the business, succeeded in saying, well, we don't have to employ you because you're not fit for the inherent requirements and there is no reasonable adjustments that can be made. It's right on the edge of the law. It's risky. And that's why we spoke particularly about Little's case, which is a case which said, well, you've got to have someone actually disclose.
Yep.
So what's the process of disclosure? The process of disclosure requires Nina saying to me, Andrew, this is the job. These are the inherent requirements of this job. This is what it actually looks like, both physically and psychologically, to be able to do that task.
Yeah.
Are you fit for doing that? Is there any injury or illness that you have which would prevent you from doing that? And I want you to sign the Section 41 under the safety under the workers' comp legislation. Similar in Queensland, doesn't exist anywhere else. Okay.
Yeah.
But in every state and territory in Australia, it is lawful to require someone to say they are fit.
But they can only do that if, like you said, you actually specify it. It's not up to them to predict what the job will involve and disclose everything. If you don't outline it, then you're the one who's going to be stuck.
Totally. And so, look, Toll and Ellis is the last case that I just want to talk about, which basically said, okay, you've got this process, which is you do all the right things. You give them the job description, you give them the task analysis, you say, look, is there anything at all that you're aware of in your own medical history that could prevent you doing? By the way, the same process applies if you're going to a doctor, okay? What Toll and Ellis said is you must bring home to them that the failure to be honest about this would lead to the termination of employment. It should be in their contract of employment. Now, I just thought we'd go through those details today and then return and look again at what Little and the Western Australian police case was about. This was a person who knew they had a physical injury.
Significant one would impact their role.
So they got through, and the nature of that injury meant they couldn't lift, hold, fire, and point a gun.
They couldn't arrest people.
They couldn't arrest people. I mean, as a police officer, that does sort of go to the
They couldn't drive a car.
Yeah.
So what could you do as a police officer?
But it just shows you that in that case they went through, and because it's the police, an inordinate procedure of over 2 years of testing and satisfying themselves, it wasn't. But what the court relied on as a result of submissions was the failure to disclose was a breach of this person's own safety obligations to do everything that was reasonable to prevent injury to themselves or others. So it was the beginning of a new piece of law coming through that we're going to talk about a great deal over the next year, which is, well, when does safety law intrude into employment law?
Yeah.
And what we're seeing in every jurisdiction is safety is playing a bigger role. Not only the way judges are dealing with it in the employment jurisdiction, but the way safety regulators are penetrating into other jurisdictions. So look, that's my summary today of inherent requirements. I'm sorry, it's sort of back to basics, isn't it? But I thought it might be helpful to actually have a chat about it. Let's go to the case study. You're across this, aren't you?
Sure. Darby was a health and safety representative at Square Peg Packaging. Actually, I had read this and it made me chuckle. His designated work group was the printing and packaging area, DWG. I'm wanting to tell you, one of the union members complained about how unfair the supervisor, Joel, was in managing staff. Darby decided to investigate what he described as a psychological hazard. He left the line where he worked without the permission of Joel, turned his mobile phone on, and surreptitiously followed and filmed Joel. The video showed Joel swearing with other employees, but not in an abusive way, just part of everyday speech. But it did include him giving directions using swear words. He sent the video to his union organizer, Claire, and asked her to attend. Claire said she would drop by later in the day. When she arrived, she said she had reasonable grounds to suspect that the supervisor, Joel, had been creating safety risks through psychological hazards. The operations manager, Dave, said he would need to know more to ascertain if it was reasonable to attend site. Claire said she had a specific complaint and verbatim evidence of a breach. She said she wanted to speak to her members. Dave said she could see them in the smoker room in 50 minutes' time. Claire said she was short of time and wanted to go on the floor. Dave said only if she received a safety induction. The plant was a dangerous plant for outsiders. Its forklifts ran about collecting packaging. There was complex packaging lines, and it was a large plant. And that would take about 45 minutes, so why not see them in the smoker? Claire pushed past Dave and said she won't be hindered by him and strode through into the production area. Darby filmed Claire push past and posted both Claire's push past video. This is terrible English. And the video of Joel on Facebook.
The only fun I have when I'm doing this, you know.
Union forced to enter Square Peg Packaging to stop thug-like behaviour from supervisor. Claire ignored traffic management floor markings and walked up to members and non-members alike, asking about Joel. When she saw Joel, she called him an effing thug bully and he should just F off back to where he belonged. Joel's parents were from Pakistan. He was born in Australia. After Claire left, FPP became aware of the posting of the videos by Darby. He was called to a show cause meeting the following day and attended with Claire. There was no enterprise agreement, and the only right enjoyed by Claire was as a support person. She shouted and berated the SPP leaders in the room, was asked to leave and refused, and eventually security were called to remove her. Darby's employment was terminated summarily. I would love to see that.
I think we do most weeks, to be honest.
I've not seen people get escorted out.
Oh, no, I have. I've actually arranged security to be present to do it. But anyway, so question one, did Claire enter lawfully? And if not, what could SPP do to prevent her entry to take action afterwards? Well, she's obliged to have a notice.
Yeah, she didn't provide any notice.
Yeah, so she might have showed a permit, but there was no notice.
You have to give 24 hours notice.
No, not under safety. You can enter straight away. So that's the difference with safety, and that's why it's often abused in this way.
Oh.
So under the Fair Work Act, you've got to give 24 hours
Yeah.
notice, but there is still a requirement under 87 to provide a notice in a form approved by the authority, but the authority doesn't approve a particular form. But it has to show the reasonable basis of suspect.
But she also hasn't complied with their safety obligations.
No, and unquestionably, they are entitled to require her to both sign in and be inducted. So no, she did not enter lawfully. Bit of a problem. This is why we're doing the right of entry training in a couple of weeks' time, because this is the sort of stuff that's so common. What could you do about that? Well, you can revoke a permit, you can do a whole lot of stuff. Not easy, expensive, hard work. But the bottom line is you can just refuse her entry and keep the doors locked is what you can do.
But she's pushed past, so you would physically remove her.
Well, that's the whole point. You not easy, is it?
Yeah.
Yeah, not easy. So, was Darby allowed to make the videos he did as an HSR? Now, this is a trick question, so don't answer it. I'll answer it. Claire is allowed to do it.
Yeah.
Darby is not allowed to do it. Darby would be a breach of proper policies occurring because he is videoing people without their consent and permission.
And posting it without the
But
consent
we're
and
still
permission.
posting it. But yes, was he allowed to make it? No, he was not allowed to make it. Okay. Can I just, we stop at that moment? I don't want to be crazy about the use of mobile phones because everyone uses them. So if there is an incident, particular physical hazard, don't say to the HSR, you can't video that. What you've got to say to the HSR is, look, please don't video people without their express consent. And there's a reason for that, and that is third-party videoing is a breach of the Surveillance Devices Act in Victoria. So if I video you, I record you, I'm allowed to do that while I'm having a discussion with you. But if I'm doing it to a third party without their consent, it's a breach of Surveillance Devices Act.
You still have to tell them that
Yeah.
you're videoing.
No, you don't. No, you don't. Not
Under
direct.
surveillance of that, yeah.
No, in every other state and territory, but not in Victoria. Okay, it's only third parties that you have to advise about. Okay, tricky, isn't it? It's crazy, but it's true. Did anything Darby do amount to misconduct? And if so, was it serious misconduct? Do you want to start listing it?
Yeah, well, firstly, the videoing.
Leaving the line. Don't forget leaving the line without consent. So
true. Yeah.
So he's an
Forgot
HSR,
about
which
that.
means he's an employee, but it doesn't mean that he can disrupt work. It means he can't be unreasonably refused what he's going to do either. But if it's in relation to investigating a complaint about behaviours, what he's entitled to do is really not leave the line to chat to people during breaks. It's not about stopping the line to do it.
And he ignored their direction as well.
Yep. Yes. So then doing the videoing and then posting it.
Yeah.
And then you've got, we don't even get to an out of work conduct because he did it during working hours. So he posted.
And he made defamatory comments as well.
Yeah. So he's in a lot of trouble, I would have thought, Darby. So let's see what the next question is. Was the termination of employment in breach of the protection of HSRs under the OHS Act? So remember,
No.
Yeah, I just want to go back and say there is both a criminal and civil division under safety legislation about discriminating for prohibited reasons, and that's for an HSR doing their role.
Yeah, but he's not doing his role.
He's not.
He's
And that's all,
exceeded his responsibilities.
yeah, that's all I wanted to highlight is
Yeah.
some of the parts of the things that he did, like speak to people, leaving the line on its own could get into some risk if it was an immediate risk to somebody. But yes, no, he would not go well in any claim that he brought under safety or the Fair Work Act. Would the safety regulator prosecute SPP for any breach, and if so, what?
Unlikely, I think. At most, giving instructions with the swearing.
Yeah, so
but
that's
it
right.
Like the banter of the.
Yeah, what we've got here is a lot of noise, but not a lot of fact.
Yeah.
Joel, the supervisor, did he do the wrong thing? Actually, we don't know because we don't know the culture in which it was given and whether swearing was a normal part of that culture. And there's a whole lot of case law that says non-abusive swearing as part of a culture is not a breach of law per se. Okay.
Yeah.
But after that, there is no evidence at all of misconduct or any behaviour which breaches safety legislation by SPP or by Joel. So I put it in there because there's a lot of noise, and when you and I get safety disputes, we hear lots of noise, don't we? But when you actually drill down, actually there's nothing wrong.
Yeah.
Okay. So that's us for today. Now, look, what I do want to do is raise one more time the breakfast that we're having.
Yeah. Right of entry. Sorry.
Yeah, the right of entry. That's a great sign, isn't it?
Yeah.
And I want to raise in that we did this problem today just to focus on how difficult it is. So what do you do with the Claires of the world? And we're seeing it daily now, the entries being used, particularly around psychological hazards, which are much more diffuse and harder to say what is the reasonable suspicion. And it's harder when they come in and show their notice and say, look, I reasonably suspect. How do you ask when they have a legal right not to identify the members, yet they're raising a psychological hazard? So we're going to talk about all those things.
Yeah, so please join us at RSVP to the admin email.
Okay. Nina, great to see you. You're still under the weather. You've had a tough run. And we'll see you all again next week, and give us thumbs up. Cheers.
Bye.